In this series, we've been covering the complexities of the estate administration process. And if you've been following along, or if you've been through the process yourself, you understand how much is involved. But for beneficiaries who are not actively involved in the estate administration process, they typically have only one question: when do I get paid? And I don't mean to be cynical about this. It's a perfectly legitimate question, and it's one that we're going to answer in this episode. We'll break down the several ways that beneficiaries may get paid and provide a general time frame for when those payments may occur. So we're going to cover 3 different ways in this episode where beneficiaries may get paid. Starting with number 1, payment from non-probate assets. Number 2, payment from advanced distributions from the estate. And number 3, payment in the form of a final distribution from the estate. Starting with non-probate assets, it's often the quickest and easiest way to get paid through non-probate accounts. So for example, many retirement accounts and life insurance policies allow the account holder to name a beneficiary directly on the account. These assets pass outside of probate, which means that the funds go directly to the named beneficiaries. The funds are not paid into the estate unless the estate or the executor is named as a beneficiary, or occasionally that can happen if there isn't a beneficiary named. But as long as a beneficiary is named on the account, those funds will pass directly to them. So if you have been named as a beneficiary on one of these accounts after a person passes away, here's what you need to know. First, you can contact the financial institution that manages the account and inquire about the claim process. They will generally provide paperwork directly to you to fill out, and they may need certain documents, including a death certificate and perhaps other estate documents. The claim forms can be confusing, so if you're unsure about how to navigate the claim process, you can contact the attorney that's handling the estate, if there is one, to help assist you. One thing to keep in mind is that there may be taxes associated with these accounts. So you'll want to know the tax implications related to these accounts before making any major decisions. This could include inheritance tax if you're in a state like Pennsylvania, where I practice. And for many retirement accounts, there are income tax implications as well. With even fewer barriers, another common type of non-probate asset is a joint account. And in a joint account, the funds in the account pass automatically at death to the surviving account holder. So I want to take a moment here and send some caution. I'm not recommending that you set up a joint account. I think that it can be a bad idea. And so while it will absolutely make for a smooth transition of assets after death, I would highly recommend that you speak to a reputable estate planning attorney in your state before setting up a joint account. Next, we're going to talk about advanced distributions. Occasionally, there will be what we call advanced distributions. These are distributions that are made to beneficiaries before the estate administration process has concluded. Sometimes this can happen fairly quickly, but other times the advanced distribution might occur only after the executor has a good sense for what assets are available and what debts need to be paid, and that could take several months to work through. So why or why not make an advanced distribution? Anytime we make an advanced distribution, we're taking some level of risk. There could be a creditor claim that we're not aware of that would come in within the statute of limitations period. The accounting hasn't been finalized, so it's possible that there was a miscalculation of tax that needs to be paid. Another potential problem is a beneficiary would later challenge some aspect of the estate administration, and this would typically only happen at the very end. So once distributions are made, we have to make a presumption that that money is not coming back, or that it's going to be incredibly difficult to get it back. And the executor may be liable for making advanced distributions if a claim comes in later and they're not able to recuperate that money. So only under limited circumstances are advanced distributions advisable. I'll give you a few examples of when this is common. So if you have an executor who's the sole beneficiary, or if you have co-executors who are the only beneficiaries, sometimes Executors are comfortable making a small advanced distribution if it may help the beneficiaries pending the final distribution. And there are times where the executor feels very comfortable, very confident that money being distributed, if it would need to be pulled back in for whatever reason, would not be difficult to get the beneficiaries to do that. Finally, the beneficiaries will be paid through a final distribution at the conclusion of the estate administration process. Where I practice in Pennsylvania, from start to finish, on average, that process takes between 12 to 15 months. So when the payment is made, the beneficiaries will be issued a release to sign prior to receiving payment. This release is a legally binding document that essentially serves as the beneficiary's approval of the executor's work, and it relieves the executor from liability as it relates to that beneficiary. Please consider subscribing to the channel if you find this content helpful, and I'll look forward to seeing you in the next episode.